Hi everybody, I'm Phil Fatica and welcome to the Millcreek Government Channel. We always have fascinating, interesting guests for you and today is no exception. Please say hello to Joe Agulia. Joe is the Executive Director of the Erie County Human Relations Commission. And you say, well, how does that relate to me? In more ways than you could possibly imagine. Am I correct on that?
That is correct.
Welcome back to this table, I like to say. This is like Charlie Rose in the table here. So the Human Relations Commission, you are an attorney.
Yes, sir.
And so what do you do when you're talking about the Human Relations Commission? What do you do? What do the people, tell those people?
We investigate employment, housing, and public accommodation discrimination cases.
And does that keep you busy?
It sure does.
No kidding. Now this is all of Erie County, would that be correct?
All of Erie County.
Okay, so let's start with, you said employment. How do people discriminate in employment?
Either
and who's discriminated against? And if you have about a day or two, you can just take that and run with it, because I know, yeah. Go ahead.
Well, race,
okay,
age,
all right,
and particularly over people who are over 40. Also, with the Americans with Disabilities Act, we have people who are disabled who may be discriminated against in employment. May not have received a public accommodation or an accommodation within the purview of their employment.
Okay.
Sexual orientation, we're one of the few counties that has that as what we call a protected class.
Yeah, I think that's important to just stop for a moment there and expand on that. My understanding is, through you, that Erie, Pittsburgh, and Philadelphia are the only three counties or areas that have this, that the other counties in Pennsylvania don't have that sexual orientation discrimination clause in their Human Relations Commission.
That's correct.
Give yourself a pat on the back. Absolutely, I think that's very important. Okay, so you got race, age, especially over 40, ADA, Americans with Disabilities, sexual orientation, anything else?
We do. Gender.
Gender.
And particularly if someone who may be on leave for an extended period of time for paternity, things of that nature as well.
So you have a full plate. There's no doubt about that.
We do.
Yeah. Let's use Phil. Okay, I'll use me as the example. I come in, I want to apply for a job. Let's say I want to apply for a job right here on the television station. And they look at me, and I look at my resume, and they have a subtle way of saying, we're not going to hire you, but we're not going to tell you the real reason. And I go to you and I say, I know they're discriminating against me. What can I do, Joseph? Please tell me. Where do I go? What do I do? First of all, where are you located? How do people reach you?
Sure. We're located on 10th and State in the Renaissance Center. We're on the 8th floor. It's the exact physical address is 1001 State Street. Okay. And that's Suite 812, the 8th floor.
Phone number, website?
Sure. 814-451-7021. And we're located under the County Council section of the eriecountygovernment.org website. Okay. And we have a specific spot there.
So you don't have a website, though?
Not for us per se, no.
But you do have a phone number, 451-7021. Okay.
So we have a web presence as through the county government website with the list our ordinance, our meetings of our minutes, things of that nature.
So just use Phil. I've been discriminated against. I want to come and work here. I know they're discriminating against me, but I can't really put my finger on it, so I come to you. What recourse do I have?
We would investigate. We would have you file a complaint with us. That complaint would then be served by mail on the responding party, whether it be an employer or a housing agency or a landlord. We would then have the opportunity to talk to the landlord or the employer, see why, see what their reason is.
So you actually physically would come up here, or you would go to them, or they would come to you, or you go to a court, or?
We would talk to them by phone. They also have the opportunity to file a response to that complaint. The complaint's the legal document. The response itself is the answer to that legal document that they would file to us. We then have subpoena power. For instance, let's say that you apply for a job and you think that someone who's under 40 gets the job just because of the fact that they are under 40. We would have the power to take a look at all the employment applications that the employer received so that we could see just to whom they actually interviewed and what resumes they received, what applications they received, what the ages of the particular people are that have actually applied, And who did they ultimately hire?
But then they look at all of that and they come back and they say, yeah, thanks, Joe, you're a nice guy, but go away, kid, you're bothering me. This is my business. You have no right interfering in my business. I've started this business from the ground up. I can pretty much hire and do whatever I please. You have no business sticking your nose in my business. How do you respond to that?
Well, we have enforcement power that we could send a subpoena out to them, and it is enforceable in court if it came to that. We also try, before we even get to the point where there's perhaps any sort of conflict between any of the parties, to, one, engage in some form of conciliation with all the parties.
Okay.
We literally sit them down at a table just like we're talking right now and try to see if there's something that could be worked out.
Right. Is it possible that when I come to you and I hear all of this and I go, Joe, I don't think I want to work for these people. Gosh, it would be living heck for me to come to work every day and live under these conditions and suffer this, whatever it is you want to be calling it. So I'm going to back away from this. So my question then is, do I have to pay you for these services?
No, it's completely free.
Say that again.
Completely free.
Okay, you are representing people pro bono.
Pro bono.
Okay, and that applies to employment. And let's say that I go, geez, this is a great job. I don't think I should have lost out on this. I want this job, okay? I want this job. Does that work out usually for most people? Do you defend them to the point where they say, no, you're wrong, you have to hire Phil at this TV station?
Well, at times that can occur. It could also be a monetary settlement if that's part of it. Sure.
Okay. So that's be employment. Now again, the employment can be based upon race, age, and I speak here because the age discrimination seems to fall for over 40.
Correct.
All right. How about a lot in the news lately about the veterans coming back saying, I can't find a job, they won't employ me, I don't know what to do, it's terrible, I just don't know where to turn. Can they turn to you?
They can't, but they can go through the government, through either Department of Veterans Affairs or perhaps another agency to go through that. They're not per se a protected class under our ordinance.
Okay, I got you. So, ADA, Americans with Disability. You have a lot of instances where you have people not able to even get into a store, let alone perhaps the facilities, the toilet facilities, the bathroom facilities, and they come knocking on your door going, hey Joe, I want to report business A over there. I can't get in it. Just, it's impossible. What's my recourse? What are you going to do for me?
We'd first talk to perhaps whatever the agency may be, whether it be a grocery store or wherever it may be, and try to see what recourse they may have to try and accommodate them, whether it be building a ramp, or some even have detachable ramps where you could put the ramp up just for the sole use of the person so they could get in there if they have a wheelchair.
Okay, but what about the restroom facilities? Because you will notice that many of these places have had, in the last couple of years, they've had to accommodate and make it so that it's accessible to a wheelchair,
Correct.
let alone the person getting out of the chair and using the facility.
Absolutely.
Yeah. You have the power to say you must do this because the government
Correct.
is going to require that you do this.
Correct.
Okay. So that would be a win for the person of the ADA. The ADA, how about the curb cuts? People are saying those are important too.
Yeah, if they are not up to code, we do have the power to enforce the ordinance to perhaps have the government or whomever installed the curbs up make them up to code.
You got a lot of power then.
We do have a lot of power.
Yeah. Who gave you all this power?
Well, one, the ordinance was enacted on the behest of the people. The people wanted the ordinance because the people wanted protection for age discrimination, for race discrimination, and in particular, now it seems to be more of an issue is sexual orientation discrimination.
Okay. So this is the person to call, 451-7021, Joe Agulia. He is the Executive Director of the Erie County Human Relations Commission, and I'm going to brag on you here. He works for you.
I do.
And not just in the city of Erie, but all of Erie County. Is that correct?
That's correct.
Okay, Erie County. So we take a look at employment. We take a look at perhaps public accommodations. which if you're able-bodied like I am and like you are, I don't much problem. I come into the store, I
No.
can squeeze sideways, I'm okay. I need to use the facilities, I go in there, it's not a problem. But do you have the power to say to these stores and places, look, you have to make this come up to code. You've got to do this because you're facing a serious lawsuit here.
You do. You do. We do have the power to do so.
Okay.
Yes.
And I noticed that the, I think, and elaborate on this if you would, I think that more and more people are becoming cognizant of that people in chairs just don't, they have a right to say, I need to get in here and you please need to do this for me. But before it was like crying in the wind, you know, oh, go away.
Public perception has definitely changed over the years. I mean, the ADA has already been almost 23, 24 years old. So, and our ordinance is based upon the Americans with Disabilities Act. So certainly public perception has changed, and I think we would maybe see a decline in those cases perhaps in coming years.
Really?
We hope to, at least. But right now, believe it or not, those are the main amount of cases we receive. The general number of cases are from people with disabilities.
Okay.
The most amount.
Okay. This is something all of us feel that we have a right to do, is to pretty much live where we want. Housing, if you want to put it that way. You can rent or you can own. And this is where I would go and say, I would like to live over there. I have the money, and I would like to rent from or buy from. And all of a sudden I would find that subtly I am not allowed to be there, or not so subtly. You go with that. You tell me, what can I do? Again, use me as the example.
Well, if you perhaps try to, let's say you send in an application to rent a piece of property, whether it be here in the city, outside the city, anywhere in the county. And for whatever reason, you go out and you meet with the landlord.
Okay.
They still say the property's for rent, at least whenever you've talked to them over the phone. But perhaps whenever you do go and meet with the landlord or potential landlord, they in turn say to you, well, the property, you know what? I just rented it out to somebody else.
Okay, you're missed by a moment.
The minute I see you,
Yeah.
they see you. The property's just rented out. Maybe an hour or two ago, you just missed it.
You just missed it, yeah.
We have the power, just as the same as an employment case, to see what applications the landlord received, what their credit rating was, their credit check, if they're all on the same footing.
So you really do peel back the layers.
We do.
Yeah.
We do.
Okay, so again, using me, and I want to live there, and I meet all the requirements. I can pay the rent, I make the money, but we don't quite like your glasses, your hair, or whatever. I'm just using that as an example. And so I come to you and I say, I think we stand a good chance here, let's go to court. Again, do you come to them in a reasonable fashion and say, hey, come on, let's talk about this, and are you sure? Are you sure?
We take a look to see if there, one, is any issues involved in it by filing the complaint, seeing if the party perhaps has any recourse to that end, and investigate it. And if our investigation doesn't turn up anything, we let the case loose. If the case does in fact have something, or at least the potential to have something, we try to engage in conciliation, just as we do for employment and public accommodation. We set the tenant down and the or potential tenant and landlord down, and at the table just as this, and try to see if they could come to a reasonable solution. Perhaps moving expenses, perhaps actually, in fact, renting another piece of property if that one isn't particularly available.
Yeah. So there are other ways to, quote unquote, skin the cat.
It's not just court, right?
Now
Definitely not.
Let's go to court. Let's take it all the way to court, and that person loses, and now you say to them, I'm sorry, but the court has found you to be not in compliance with anything here. I'm raising my hand going, wow, I get the jackpot, or what do I get? What do I get? A lot of money, or I get the right to live where I wanted to live in the first place?
It could be moving expenses or monetary damages. What the general process does, though, the complaint would be filed, the landlord would have an opportunity to file an answer to the complaint, just as the employer would in any case. There would be a period of investigation, and then in turn, a period of conciliation, if in fact the case has merit. Then it would go in front of our commissioners. There's 9 commission members, and there would be a hearing in front of those commission members. So it wouldn't be a court to the extent of what most people are used to, where a judge is set at. This would be the commission members acting as judges. Picture them in your proverbial black robe.
Okay, okay.
And the appeal right then would be to the Court of Common Pleas, to one of the judges, whoever's assigned to it. But the damages, if you will, if someone is in fact, whether it be a landlord or an employer, found in fact to have been violative of the law in some fashion, could be monetary damages, it could be moving expenses, could be front pay, back pay, could be, for instance, expenses in helping to try and find another piece of property that they could rent. Whole slew of
choices. So how long does it take? I go and I say, I think my case is pretty strong. You look at it and go, yeah, I think it does too. From me starting to completing, is it a moving number, or is it generally realize this is going to take a little longer than you think, Phil?
It's a moving number to the extent of this. If the other party, whether it be the employer or landlord, is perhaps in some fashion able and willing to negotiate, it could be as little as a couple months.
Okay.
On the long end, if it did in fact go to the commission members for a hearing, it could take up to about around 8 to 10 months.
Okay, so it could be pushing a year.
Could be pushing a year.
Pushing a year. Okay.
Correct.
Let's just assume, we're on a good 2-shot here. Let's take the table here. Let's assume that this didn't exist. Human relation commissions did not exist. That I went to these places, my job, my employment, everything, and I just simply got shut out. Tough luck? Was that about it? Who am I going to go complain to? Because Phil, you're nothing but a bellyacher and a moaner and a complainer, because you're the only one that's doing this. Nobody else is doing this. Why don't you just shut up and just go along to get along? I mean, what did people do when they couldn't have a recourse?
If there was no recourse, they wouldn't be able to get the action, at least in some fashion, a redress of what they're entitled to by law. A lot of people that come to us can't afford an attorney. So they come through us to, one, investigate the case, and 2, not necessarily to act as their attorney. We investigate and we remain neutral. So we're not their attorney to that end, but we investigate it and at least get on them in a level playing field as far as what the facts are and what the true facts are as far as the case goes. So if you didn't have it, unless they had the money to pay for an attorney, too bad, so sad.
How many of those cases, let's say, do you quote, I don't want to use the loaded words, win for the clients? I mean, where does the balance go, for example? Who or how does it usually go for you? Do you usually get more wins than you do losses,
They usually
or pluses and minuses?
They usually go to settlement. And what I mean is perhaps there's a meeting of the minds between the parties, and there's a form of settlement that the terms of which usually aren't published as far as the settlement agreement goes.
Yeah.
But it could be, as I said, anything from somebody getting a job or regaining their job to someone getting an actual piece of property to rent. So usually the majority of them, as far as a numerical percentage, probably about 6 to 7 out of 10 would come to an agreement.
Okay.
The rest could be deemed maybe 30% frivolous or 25% frivolous.
Yeah, good word. I was just wondering, what do you do? Does anybody ever come to you with a class action suit and say, we're all going in against Phil, he's the evil guy here, and we all got this proof, and do you handle those, class action?
We take a look at those to the extent that we have the power and jurisdiction under our ordinance. The act has to have occurred within the last 180 days.
Okay.
So if it occurred over a year ago, then they automatically have to go to court.
Okay.
They can't go through us.
Are you at liberty to discuss not necessarily one here, but generally speaking, that it's in the lawyer books and say, here's the classic case and here's what happened. Can you discuss that, for example?
Sure.
Yeah, without naming names, perhaps. I'm not sure about that, but yeah.
Well, here's a couple. One in which someone perhaps wanted to use another bathroom. They actually made a unisex bathroom for the individual employee because of their disability, or perhaps because of their sexual orientation.
Okay.
That'd be one that perhaps came to some conclusion. Another one would be an individual who received back pay for their work, and they didn't receive their job back because they didn't want to go back, but they did receive back pay from the time they were discharged to the time they actually found new work. Now, they have to try to at least minimize their damages. What I mean by that is, well, you don't want them to sit around and do nothing to try to find a new job in the meantime, because that would enable the employer to have a defense to basically say they haven't minimized their damages to the extent of trying to find a new job or a new piece of property to rent in those instances. So you have to make them aware of that.
I'm glad you mentioned something that triggered a question to me. This is not anti-employer people,
No.
anti-landlord at all. I mean, I don't think we want to give people that impression that you're defending only these people, because some of these people can have some really not good requests. I mean, their requests are completely out of bounds.
They can be totally frivolous
Yes,
requests.
totally frivolous, yeah. So does the employer then have the right to come to you and say, hey, look, this person is way out of line on this. I believe that he or she's just wasting your time, and let me give you some background material to help you?
Absolutely. Before we even subpoena those documents, they could, in fact, send to us an answer and a position statement, say, well, hey, wait a minute, this case is bogus, this case is frivolous, and here's why. And they outline those steps, and they outline why. So to that end, we, and I want to stress this, are a neutral fact finder. Picture the commission members and the commission staff as judges. We investigate the case, we take a look at the case to see if it has merit. If it does have merit, we try to engage in conciliation, negotiation. If it does not have merit, it's dismissed.
Okay.
Plain and simple.
Okay, so you were judging for me. Okay, I'll take the job here in the TV station again. I go, hey, you guys are wrong. I'm sorry. You're 9 people over there. They're all full of hooey. I don't believe anything you say. I'm going to court. I'm taking this to a court of common pleas. I have that right to do that?
You do.
Okay.
You do.
But it's going to cost me now, because I probably will have to hire an attorney.
would
How
have
can I
to-
defend myself?
You would have to hire an attorney. You can, if you're an employer, you can defend yourself. Now, the majority of complainants, they don't have the money to employ for that. And not to take away from employers, the majority of employers, for most part, do have the money for an attorney. Your smaller employers and your smaller ones that have, and I want to stress this too, we don't take a look at those cases that have employees of 4 or less.
Okay.
So if it's a small employer, they have, if you will, an exemption under our ordinance, because if they just have 2 or 3 employees, we don't even take a look at it.
Okay, good information. So taking all of the discrimination cases that you handle, there's the employment, there's sexual orientation, there's public accommodations. Can you rank them, like which has the most, which has the second, and then the ones that, we don't get too many of those?
We thought we would get a lot of sexual orientation cases, and that was one of the, if you will, concerns people had about it, that it would open the floodgates of litigation.
Right.
But in fact, it did not. That was one of the cases in particular, one of the issues where we don't get as many cases in particular. As far as the hierarchy would be, it would be cases involving people with disabilities, without a doubt. And then race, then gender. Someone who perhaps maybe is working for an employer and had to go on maternity leave, or perhaps more or less may be held to a gender stereotype. For instance,
I noticed something on one of the morning talk shows just the other day where men who are taking care of babies more and more now, you go into the men's room to change the diaper, there's no changing table in there. They're in the ladies' rooms, but they're not in the men's rooms. So could I come to you and say, hey, look, I want to force this TV station to make that men's room have a diaper changing station there because on X, Y, and Z. Could you handle that?
You could.
Really?
Sure.
Oh, that,
Sure.
That might roll out, I think, because more and more men are saying, I'm taking on this role. What am I going to do? Change my child by letting them just simply sit on the concrete down here or something?
And to some degree here, I would think that you would see that more often than not. I'd often see it in McDonald's. It's starting to come around. McDonald's in particular has baby changing stations for the men restrooms. So.
Yeah. All right, this is Joe Gould again, and Joe is the Executive Director of the Erie County Human Relations Commission. They're located at 10th and State, 8th floor. Phone number is 451-7021, and they handle cases of, well, what do you handle? You tell them. You're the boss.
Employment, housing, and public accommodation discrimination cases.
Right. And if you ever had any of those, then this is the person to call and to even say, hey, do you think and he'll give you the way to go and say, first you need to, and be aware that, though, you may be judged frivolous here. Just because you called me and I talked to you doesn't necessarily mean...
Doesn't mean you have a case. We have to treat it with kid gloves and see every case and treat it neutrally.
Give me a number if you can. How many cases do you treat, see, discuss, investigate in a year?
A year, anywhere from 75 to 100.
Okay, so it's legitimate, and you're looking at maybe 10 or so a month, because they take a long time to investigate.
They do.
And you're a staff of one?
Staff of 2.5.
Two and a half, okay, 2.5, and that takes a little while. So again, thanks for taking your time to be up here. Appreciate that you know that this service is available to you free of charge. It's the Human Relations Commission. Joe, again, thanks for being here.
Thank you very much.
Continued success to you. Thank you very much for joining us, everybody. I'm Phil Fatica. Again, thanks for joining us, and until we meet next time, take care.